Dear colleagues and friends, it is an honor and also a pleasure to address you at that important conference, although I must confess I would have preferred to speak to you directly. The topic of my speech is Land Dominates the Sea. Is there a need to reconsider this concept once phrased by the International Court of Justice? This concept has been coined by the International Court of Justice in its judgments in the North Sea continental shelf cases. The court made that statement for two reasons: to justify the national encroachment on maritime spaces, the contiguous zone and the continental shelf, and as a determinative factor in the delimitation of such spaces. To back up the dictum that land dominates the sea, the court argued that, and I quote, "the land is a legal source of power which a state may exercise over territorial extensions to seaward." End of quotation. This sounds as if the court was referring to the traditional three elements which make up a state, namely territory, population, and the government, considering the territory as being the dominant element. In 1969, this was a prevailing view, but as of today, there is a growing, if not a dominant tendency that the main element of what qualifies a state is a population. However, one may add that the International Court of Justice, in formulating this dictum, was in line with a historical understanding on the status of the territorial sea. In the 17th century, the territorial sea was considered as the property of the coastal state concerned, acquired by occupation, as has been formulated by Bunkershoek in his text De Dominio Maris. There he had introduced the canon shot rule as a hypothetical standard of measurement how far the coastal state could extend its territory based upon power from the shore. Returning to the dictum of the International Court of Justice, it has not always been fully appreciated that this dictum covers two separate, although intrinsically connected issues, namely the justification for the extension of state power to maritime space, delineation, and the configuration of such space vis-à-vis neighboring or opposite states, delimitation. A quick perusal of the international jurisprudence concerning the delimitation of maritime spaces, be it the territorial sea, the exclusive economic zone, or the continental shelf, demonstrates that the procedure developed over the years to that extent is guided by the concept of the land dominates the sea. In the following, I shall question whether the concept land dominates the sea from 3 points of view, namely the influence of the sea level rise on baselines and the continuing existence of national maritime spaces, and whether geographical and geophysical considerations should continue to govern dominantly the delimitation of maritime zones and what qualifies a state as a coastal state. Let me turn to the sea level rise first. It has been argued that the expected sea level rise will lead to the shifting of baselines, and that, as a matter of consequence, this means that all maritime borders depending upon baselines will have to shift accordingly or have to be renegotiated. This would affect the boundaries vis-à-vis neighboring states, opposite or adjacent, as well as the delineation of the exclusive economic zone and of the continental shelf if no outer continental shelf exists. The Baseline Committee of the International Law Association had originally stated that in I quote, extreme circumstances, landward changes of baseline, could result in total territorial loss and the consequent total loss of baselines and of the maritime zones measured from those baselines. End of quotation. Although I understand the logic of the arguments, I nevertheless disagree with the interpretation, the UNCLOS-based regime on baselines. In consequence thereof, I disagree with the qualification that baselines are ambulatory. I'm pleased to note that the ILA Committee on Sea Level Rise in its recent report took a more balanced view than the baseline committees. It has further been stated by the Baselines Committee that the sea level rise may lead to the loss of islands and rocks and thus to the territorial substance of island states, and that public international law does not provide for a humane solution for such cases. I agree that this would mean a human catastrophe, and it is here where the concept of land dominates the sea should be given up or modified. I shall come back to that. However, also the baseline system established under UNCLOS Part 2, Section 2 has to be detached in part from the concept land dominates the sea. 3 baseline systems exist under UNCLOS, namely normal baselines, straight baselines, and archipelagic baselines. Sea level rise will affect them all in different ways. Therefore, treating them as one is not fully adequate. There are several means to establish maritime boundaries. As a matter of principle, maritime boundaries depend upon the consent of the coastal states concerned. This is explicitly stated in the last sentence of Article 76, paragraph 8 UNCLOS. Coastal states have established maritime borders unilaterally based on their declared baselines as provided for in UNCLOS Part 2, Section 2. Coastal states have further entered into agreements with neighboring countries establishing maritime boundaries. In respect of these agreements, it is not always clear whether baselines were taken into account. Frequently enough, other considerations, such as established fishing rights, played a dominant role. Judgments and awards of international courts and tribunals have decided a significant number of maritime boundaries, again taking into consideration unilaterally declared baselines or not. For example, in the delimitation cases between Bangladesh and Myanmar and India, respectively, the baselines claimed by these states did not play a role. Also, these boundaries are consent-based, since adjudication depends on the consent by the coastal states concerned. To unravel the established system of maritime boundaries would be contrary to one of the leading principles of public international law, namely legal security. This principle would clearly be jeopardized by insinuating that baselines are neither stable nor may be rendered stable. The reference to the necessity of stability of maritime borders are highlighted by the arbitral tribunal in the maritime delimitation case between Bangladesh and India may be considered a pragmatic reasoning. It, however, reflects object and purpose of borders in general and maritime borders particularly. This consideration is to be set against the underlying rationale of the concept land dominates the sea, with the consequence that the latter cannot be considered as being absolute. It seems as if the proponents of ambulatory baselines intend to apply the concept land dominates the sea verbally. However, Article 7, paragraph 2 UNCLOS already indicates that at least straight baselines are not so clearly determined by the land. Apart from that, let me add 3 legal arguments against qualifying baselines and the maritime boundaries depending upon these baselines as ambulatory. The first one concerns the interpretation of Articles 3 and 4 UNCLOS. These 2 provisions prescribe that the outer limit of the territorial sea shall not exceed 12 nautical miles measured from the baseline in quotation. Article 33, paragraph 2 UNCLOS uses the same formula, so do Articles 48 and 76, paragraph 1 UNCLOS. It is evident that these provisions are to be applied when the coastal state determines its maritime boundaries. None of them indicates that these delimitations should be reviewed from time to time or adjusted. Those who claim that these boundaries are ambulatory and have to be adjusted read an additional clause into the provisions quoted. I see no justifying reasons for such interpretation. As a matter of principle, facts in themselves cannot change the law. Let me come to my second argument. According to Article 16 UNCLOS, and I quote, the baselines measuring the breadth of the territorial sea or the limits derived therefrom and the lines of delimitation drawn in accordance with Articles 12 and 15 shall be shown on charts. What is the meaning of this provision, which is more or less repeated in respect of the other baselines dependent boundaries referred to? The meaning is evident. This documentation is meant to establish a legal security. Here again, no indication is provided for that these charts are to be revised from time to time. My third argument relies on general principles of public international law concerning land boundaries. Certainly, maritime boundaries are not identical to land boundaries, and particularly not the ones delineating the exclusive economic zones from the high seas or the continental shelves from the area. However, maritime boundaries in respect of neighboring states have similar functions as land boundaries and the lateral boundaries of the territorial sea. The same applies to archipelagic waters, ARC, considering the status of these maritime areas equivalent to land boundaries. Additionally, one may refer to the fact that the clausula rebus sic stantibus may not be invoked in respect of the establishment of boundaries. This is a clear indication that international law tries to avoid uncertainties about boundaries. The reason behind these 2 rules is evident. Boundaries are to be protected against changes. States should be able to trust in the permanence of boundaries, since disputes about boundaries may lead to belligerent conflicts. What is the appropriate way out of the alleged uncertainties concerning maritime boundaries? First, it is recommended that coastal states document their baselines as well as the coordinates of all their maritime boundaries. The ILA report seems to support this approach and indicates that some coastal states have already started this exercise. Such documentation, in particular if undertaken by several states, constitutes subsequent practice in accordance with Article 31, paragraph 3b of the Vienna Convention on the Law of Treaties concerning the interpretation and application of the rules on baselines. Second, it would be advisable if the UNCLOS meeting of parties adopts a statement giving an interpretation of the provisions referred to and thus putting an end to the uncertainty that may have been created. Sure, so far the meeting of parties has no explicit mandate to issue interpretive statements concerning the Convention. The meeting of states parties of UNCLOS is, however, advised to follow the example of other meetings or conferences of states parties, particularly from multilateral environmental agreements. Whichever solution is being effected, it will, in fact, weaken the connection between the concept land dominates the sea. What will count will not be the relevance of the land at any given moment, but only when the delimitation was established. Let me now turn to the anticipated vanishing of islands and rocks. It has been recommended that island states should take technical measures to protect against the consequences of sea level rise. Some have already started to do so. This does not, however, absolve international law to produce an answer concerning the following question. What happens to the states concerned? What happens to the populations? And what happens to the maritime zones? The dogmatic prime consideration to answer these questions is what constitutes a state. According to Article 1 of the Montevideo Convention on the Rights and Duties of States of 1933, which I quote, the state as a person of international law should possess the following qualifications: A, a permanent population, B, a defined territory, C, government, and D, capacity to enter into relations with other states. End of quote. In fact, it is the question whether this axiom is still valid, or in other words, whether the definition of what qualifies an entity as a states should be more flexible. Traditionally, it was held that the territory was the most constituent factor of statehood. Considering the overwhelming acceptance and relevance of human rights in international relations, the most important factor should be the population. There are several different possibilities how to safeguard the population of island states, which is actually a humanitarian demand. States should cooperate in this matter as requested already by Emery de Vattel. It is a matter of interstate solidarity. However, even if the population of a vanishing island has found a new homeland, this does not solve the legal questions concerning the continuing existence of the state. The most radical solution would be to accept that there may be states without a territory consisting of a population but having a government of its own and being able to enter into international relations with other states. Such a redefinition of statehood requires a universal discussion and the acquiescence in what are the qualifications of a state. It has been argued that in the past states have existed over a certain period of time, although their territories had been occupied by other states. The occupation of states was considered as illegal, and therefore any legal effect of occupation would be denied. The situation of the vanishing states, however, is the consequence of a factual development. Accepting states without territorial basis, which I would recommend, would mean that the concept coined by the ICJ, that land dominates the sea, if that concept is to be understood that there cannot be national maritime zones which are not connected to land, has to be modified. These considerations may sound utopian. However, it is a demand of humanity that solutions be developed which not only give the population of vanishing islands a new homeland, but also find ways and means to safeguard the existence of island states, being an enrichment in the world's system of statehood. Let me now turn to my second issue, the delineation and delimitation of maritime zones. The delineation of the territorial sea, the exclusive economic zone, and the continental shelf are all defined by references to baselines, while the configuration of the latter are dictated by the geography of the coastal state concerned. It does not matter whether the latter is a continental state, an island state, or an archipelagic state. The overriding relevance of the geographical configuration of the area concerned has been emphasized by the international jurisprudence frequently. The existence and the seaward extension of the continental shelf beyond 200 nautical miles depends on geographical considerations. Article 76, paragraph 1, of the natural prolongation of its, namely the coastal state's, land territory to the outer edge of the continental margin. The same is true in respect of delimitation of maritime zones. The first step undertaken in this context is to define the relevant coasts that generate overlapping claims in the disputed area. Geographic considerations are also dominant in the construction of a provisional equidistance line, the consideration of the relevant special circumstances, and the final proportionality test. Under these circumstances, it is not astonishing that in delimitation disputes, dominantly geographical and geophysical considerations are invoked by the parties. However, occasionally other arguments are advanced, such as established fisheries rights or historic consideration. From the fact that Article 74 and Article 83 UNCLOS do not refer to potential historic interests, whereas Article 15 UNCLOS does, it has been deduced that such interests do not play a role in the delimitation of the exclusive economic zone or the continental shelf. I refer to the dissenting opinion of Judge Oda in the Tunisia-Libya dispute, whereas Judge Jimenez de Arriaga took the opposite position. The Guyana-Suriname arbitration showed some flexibility in this respect, accepting Suriname's navigational and security interests. In the dispute between Ghana and Côte d'Ivoire before a special chamber of ITLOS, Côte d'Ivoire argued that, as a matter of solidarity, Ghana should share some of its hydrocarbon resources with Côte d'Ivoire, since such resources originated from the shelf common to both states. The special chamber dealt with this argument, but finally dismissed it. This brief outline concerning the jurisprudence concerning delineation and delimitation of maritime zones demonstrates two issues, namely, that there exists, at least so far, a rather limited catalogue of arguments predominant in such disputes being based upon territorial considerations. Taking into account which economic impact delimitation decisions may have, and considering further the close relationship between the parties, one wonders whether this limited catalogue of possible arguments should not be unraveled so to give more room to considerations, paying tribute to the interdependency of the states concerned. Let me come to my third and final issue. So far, the question did not arise as a central point as to whether a state qualified as a coastal state. This issue was problematized in the Chagos Marine Protected Area arbitration, the Republic of Mauritius and the United Kingdom of Great Britain and Northern Ireland award of 18 March 2015. In its final submission, Mauritius requested the tribunal to declare that, I quote, "The United Kingdom is not entitled to declare an MPA, Marine Protected Area, or other marine zones because it is not the coastal state within the meaning of inter alia Articles 2, 55, 56, and 76 of the Convention." End of quote. The tribunal, by 3 votes to 2, found that it lacked jurisdiction on this submission. A special chamber of Intl took up this issue again in the dispute between Mauritius and the Maldives. Disputes concerning the delimitation of the marine boundary between Mauritius and the Maldives in the Indian Ocean. It held, referring to Resolution 73/295 of the General Assembly, which required the United Kingdom to withdraw its administration over the Chagos Archipelago within 6 months from its adoption, and the fact that the United Kingdom had not complied with this demand, that the United Kingdom's claim to sovereignty over the Chagos Archipelago is contrary to the authoritative determinations made by the advisory opinion of the ICJ. From that, the special chamber deduced that it was inconceivable that the United Kingdom can have any legal interests in permanently disposing of maritime zones around the Chagos Archipelago by delimitation. The special chamber, at par 250, concluded that Mauritius can be regarded as a coastal state in respect of the Chagos Archipelago for the purpose of the delimitation of a maritime boundary, even before the process of the decolonization of Mauritius is completed. This judgment has been criticized for rendering the advisory opinion of the ICJ into a legally binding decision. In my view, this is not the case. The ICJ has interpreted the factual and legal situation correctly, and it was for the special chamber of Intl to formulate the consequential conclusion in legally binding terms. What is relevant in the context dealt with here is that a state whose claim to act as a coastal state is in violation of international law may lose such qualification. This should be taken as a further indication that the concept land dominates the sea has a geographical as well as a legal connotation. The legal as well as the geographical aspect should be considered separately. It is quite evident that this constitutes a modification or aberration from the concept of the land dominates the sea as traditionally understood. Judge Oxman indicated this in his separate and dissenting opinion. Let me briefly conclude. This brief keynote speech may be considered provocative. Its main purpose was to indicate that the concept of land dominates the sea should not be considered as a solid rocher de bronze, but requires reconsideration. This does not mean that this concept should be abandoned. On the contrary, it will remain a decisive element in deciding on the configuration of maritime zones, but it should be supplemented. In particular, it should not become a mechanism which forecloses solutions for the population of vanishing islands. I hope to have initiated a discussion on how this concept can and should be modified to meet the challenges the people who live close to the sea or from the sea are facing. Thank you very much for your attention.